Yesterday I made a mention. Can it be taken out today? That matter today?
No, I know that it has been posted to Friday because after
because
his
of the urgency matter, it's already 10-15 days.
it's all
The
right,
old parents are there. This
after lunch there is this one after another
before
things
lunch. Before lunch.
it's not possible. I have already said that it will be listed on Friday. It will come on Friday.
Because the parents
You
here
have mentioned it.
peculiar matter. That is why I am
Just a minute.
repeatedly mentioning. Otherwise, I would not have
Friday.
mentioned.
Friday it has been already because of this paucity of time today, because of this.
That is the situation of the case is also like that. That is why I made a repeated.
All right, it will come on Friday. Yes.
I may be passed. 201 identity list 201 not test error. Surrender certificate I filed on 17/8/2000.
Yeah, just a minute.
Hello, click just a condition, my lord.
Wait, please wait. 201 you want to not press. File the memo. It's post office. Yes.
I may against a conviction, my lord. I have filed a
Please give it.
I may be pardoned, Lord. The matter was adjourned 29th August, Lord. The matter has not been listed.
What is that matter?
Matter is the only orders, criminal appeal matter. They already had the area, mathematical area. My senior was.
It's for hearing.
Lordship, hearing the orders matter.
Give the matter.
Lordship, the Friday or Monday.
We'll see that. This week it is not possible. Next week we'll see.
Petition is a juvenile, my lord. Special act.
Bail matter.
Bail matter.
Give it.
Juvenile. Friday.
Your Lordship, CRLA number 989 of 2023, the petitioners were on interim bail till 3rd September. Your Lordship, the petitioners were convicted under section 307, 324, 325 and 323 under IPC. Your Lordship, can this matter be taken up on Friday?
Give it, we'll see that if it is.
Obliged.
Item 178, my lord, cardiac patient is admitted into MKCG medical.
You see that, please. Just make note it, we'll see that. Yes, please call them. Who jayithila?
87, I think 67.
67. Okay.
Weekly list, item number 67. 868.
Please, my lord. My lord, here the appellant is convicted under section 304, part 2, and also sentenced to undergo the imprisonment for 10 years. My lord, out of 10 years, he is already in custody more than 6 years, 5 months. And he is also in custody since 26 February 2017.
Trial court record. What is the date you said that you were in custody?
26 to 2017. As I calculated, that is 6 years, 5 months out of 10 years.
Custody is 28 to
26.
2017. Right, and you are not on bail due
No.
to trial.
No.
6 years, 6 months.
Sir, 6 years. 6 months.
And what is the sentence imposed by the
304, part 2, 10 years imprisonment. Sentence, my lord, is page 17.
eyewitnesses are there?
Yes.
Who is the eyewitness?
1, 2, 3, 4.
You assaulted by means of a wooden medha
Wooden,
on the head.
yes.
Deceased is Banambar Malik.
My lord.
PW 1, 2, 3, and 4.
4 is.
Eyewitnesses.
Yes.
Doctor is
Doctor is 10. PW 10. Para 3 as stated.
okay. Yes, Mr. Misra, you have received the deposition copies.
Yes, ma'am.
Okay. So these 4 eyewitnesses have supported the prosecution.
Yes,
And doctor's evidence is also there.
yes, ma'am.
Lacerated wound was found on the scalp midline, and cause of death was subdural hematoma. Cause of death is homicidal nature. All right, heard the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submits that the petitioner is in judicial custody since 28 to 2017. And as such, out of 10 years of substantive sentence imposed on him for his conviction under section 304 part 2 by the London trial court, he has already undergone sentence of 6 years and 6 months, and there is no chance of early hearing of the criminal appeal in the near future, and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and placed the evidence of eyewitnesses, that is PWs 1, 2, 3, and 4. He further submits that the eyewitnesses are consistent that on account of wooden medha blow given by the petitioner to the deceased Banambar Malik, the death has taken place, and the doctor has specifically stated that the cause of death was due to subdural hematoma. and it is homicidal in nature. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during trial, sentence imposed by the land and trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail.
Obliged.
Item number 69.
What
Item 72.
72, may I please your lordship? My lord, on last occasion, it was directed to my lord, submit the deposition copy. My lord, I have served the copy on dated. My lord, 27/7/2023, I have submitted the copy.
Deposition copies are available with you, Mr. Misra.
Yes, ma'am.
My lord. My lord, conviction under section 29 of the NDPS Act. And my lord, the sentence imposed is 10 years, my lord. The operating portion is at running page number 57 and internal page 47.
Hmm.
If your lordship permits, may I please?
Conviction is both under section 21C and also 29.
My lord, 21C is for the other co-accused, my lord. I'm
Sukant Sethi for.
Sukant Sethi. I'm not Sukant Sethi, my lord. I'm Devendra Bisai.
Okay.
My lord, third last line on page number 57. That convict Devendra Bisai is sentenced to undergo rigorous imprisonment for 10 years and fine of rupees 1 lakh. In default, undergo imprisonment for 2 years under section 29 of the NDPS Act. My lord, so far as my implication in the present case is concerned, my lord, may I draw my lord's attention to running page number 53.
Yes.
My lord, second para, fifth line, my lord. There is consistent evidence. So lordship is having. There is consistent evidence of PW1, PW2, PW5, PW6, and PW7, PW11 that the packet containing brown sugar was recovered from the possession of the accused Sukanta Sethi. The evidence of the aforesaid PWs is silent about involvement of the other co-accused person except the accused person Devendra Bisoi, from whom cash of rupees 1150 was recovered and seized, my lord. My lord, so far as my involvement in the concerned case is in the present case is concerned, my lord, only 1150 rupees has been recovered, and my lord, subsequently I'm in custody since, my lord, 24/11/2020, and my lord, I was released on bail on dated 6/4/2022. My lord, subsequent taken into judicial jail custody, my lord, on 30/7/2022. My lord, if a lordship holds the bail order, my lord, also BLAPL number 883 of 2022, it has been categorically stated, my lord, that due to the position of the contraband articles which has been seized from the co-accused, on that basis, my lord.
Mr. Misra?
Yes, madam.
So 29 requests that it deals with the punishment for abatement or and criminal conspiracy. So admittedly,
The present petitioner was along with other co-accused, that is Sethi.
No, the line which the Lennon Council for the appellant placed, from that it reveals that at least the witnesses are stating about the recovery of brown sugar.
Recovery of powder-like substances
from the accused Sukanta Sethi.
Yes, ma'am.
Have they stated anything against this petitioner?
No, only cash was recovered. But he was along with that Sukant Sethi.
When the arrest was, let us see the table. Which witness, Mr. Misra?
All official witnesses, madam.
PW1, let us say.
The lordship may see PW1 para 2.
We proceeded to the spot in the official vehicle, found 6 persons were standing with suspicious condition. SI called 2 witnesses and we surrounded them. Identity was asked. Then
relevant portion is one packet containing brown sugar was recovered from the possession of accused Sukant Sethi. Cash of rupees 1150 was recovered from the possession of accused Devendra Bisoi. That is para 2
Uh,
last. Before cross answer.
my lord, only cash of rupees 1100.
wait, how are you?
My lord.
So suppose 6 persons were standing. One of the person has kept something in his pocket, and that is commercial quantity of brown sugar.
Yes,
And another person who is talking with that person is having some rupees, that is 1150.
I am followed by that conscious possession is not there.
No, how can you say that here there is conspiracy between the two?
But there was conspiracy and there was the present petitioner was along with that.
No, yes, all right,
Sukant
it is standing there, but for conspiracy we have to do something more, because it might not be within the knowledge of the person that he was having brown sugar with him in his pocket, and he might be just talking. So you are convicting the person with the aid of section 29 on the ground that he is conspiring with the main accused. So where is the basis of that, except that he was standing with him, and nobody has stated that when that these persons approached police party, they started to run away from that place.
Yes,
Though that would have been a suspicious conduct.
yes,
So that is not there. Are the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the judgment of court Learned Counsel for the petitioner submitted that the petitioner, along with five others, faced trial under section 21C and 29 of the NDPS Act on the accusation that they were in unauthorized possession of 270 gram of narcotic brown sugar, which was of commercial quantity, and there was criminal conspiracy between the accused persons to commit such offense. The Learned Trial Court, after discussing the evidence on record, has been pleased to hold that there is consistent evidence of PW1, PW2, PW5, PW6, PW7, and PW11. That is in paragraph number 21C, running pages 53. That packet containing brown sugar was recovered from the possession of co-accused Sukant Sethi, and cash of rupees 1150 was recovered from the possession of the petitioner, and it was seized. The Learned Counsel further submits that while acquitting the other four co-accused persons, the petitioner was found guilty under section 29 of the NDPS Act only on the ground of recovery of cash of rupees 1,150 from his possession without any material that the petitioner abated the commission of crime or had any criminal conspiracy with the co-accused Shukanta Sethi, from whose possession the brown sugar of commercial quantity was seized. And therefore, the conviction of the petitioner under section 29 of the NDPS Act is unwarranted. Learned counsel for the petitioner further submits that even though section 37 of the NDPS Act is a bar for consideration of the bail application, but since the finding is perverse and there is no clinching evidence on record to prima facie attract the ingredients of the offense under section 29 of the NDPS Act, and there are good chances of success in the appeal, and balance of convenience is in favor of the petitioner, the bail application may be favorably considered as he was on bail during trial. Learned counsel for the state oppose the prayer for bail and place the evidence of PWs 1 to 5, 6, 7, and 11. Considering the submission made by the learned counsel for the respective parties, nature of evidence available on record against the petitioner, since from the evidence of the witnesses, there is absence of, prima facie absence of material regarding abatement made by the petitioner to the co-accused Sukant Sethi to commit the crime, or absence of material to show criminal conspiracy between the two, except that cash of rupees 1,150 was seized from the possession of the petitioner. Keeping in view the fact that there is no chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail, stay realization of fine, IA number so and so for interim bail, not rest.
Grateful, my lord. Highly obliged.
for committing offence 20B2C of NDPS Act, internal page 40, running page 48, my lord. The judgment.
How many persons have preferred this?
3 persons, three appellants.
There are 3 appellants. So it is 20B2C, 10 years, 10,000, and okay. Yes. What is the period of detention?
More than 7 years, 9 months more, my lord. Till custody since 13/12/2015. 13/12/2015. 7 years, 9 small more, 12, 13, give 10 months.
All the 3 of you are of Bihar.
Outsider, my lord.
So address verification has been made, Mr. Miller.
Yes.
It is found to be correct.
Yes, sir.
So give him the names, address, and documents of local sureties who are interested to take the petition.
Blood related relation kardele hoba relation.
You give
Yes,
the
my lord. Yes, my
local sureties of this so that
My lord.
okay.
My lord.
The Learned Counsel for the state has verified the address of the petitioners, appellants, and submitted that it is correct. Declared the Learned Counsel for the as a Learned Counsel for the petitioners submitted that the petitioners are in judicial custody for more than 7 years and 9 months out of 10 years of sentence imposed by the Learned Trial Court. Let the Learned Counsel for the petitioners supply the names, addresses, and documents of 2 local sureties who are interested to take the petitioners on bail within a period of how many days you want it?
10 days.
10 days. And on receipt of the same, the London State Council shall verify about the authenticity of the bailers and genuineness of the documents. List this matter 10 days or 10 days ପରେ ଆଉ ଗୋଟେ ସପ୍ତାହ ଛାଡି ଦିଅ ତାପରେ ଡେଟ୍ ଦେଇଦେବ ହେଲା yes
Item 77.
77 may kindly pass over. Last occasion, your lordship also direct to address verification.
no address verification has been made.
Miller, it has already letter is sent, but is not received, madam.
He's a man from West Bengal.
Yes, madam. Already communications have been sent to the West Bengal.
Okay, the London Council for the state submits that intimation has already been sent to the concerned authority for verification of the address of the appellant, and the response is awaited, and the matter may be taken up a week after. List this matter in the week commencing from 18th September 2023.
Always.
Item 78. Item 80.
Mr. Panigrahi,
May I please, my lord? Now the conviction under section 304 part 2, my lord, for 10 years and 20.
have you supplied deposition copies?
Yes, my lord, yes.
Come to the operative part of the judgment, page number.
My lord, page number 37, my lord. Judgment page no 37.
Okay. RI for 10 years, 20,000. এটিকে কমে দাও। And RI for 1 year under 304 part 2. Then RI for 6 years, 6 months under 323. And concurrently, okay. This is CRLA 176/2023. So you are on bail during trial or in
No, ma'am.
custody? Since when you are in custody?
2/4/2020, 2/4/2021. 3 years, 5 months.
Trial court record. Who is the deceased in this case?
Kontur Machi, father-in-law of the appellant, my lord.
Who are the eyewitnesses to the occurrence?
Eyewitness PW1, the wife of appellant, as well as the daughter of the victim, deceased, my lord.
Wife of appellant.
Yes, my lord. There was a quarrel between wife and husband, and thereafter the unpleasant situation happened, my lord.
So how the deceased is related to the appellant?
Yes, my lord. Father-in-law, my lord.
Shasura.
Yes, my lord.
Father-in-law of appellant. Okay, so your wife has deposed against you.
Yes,
So let us say what she has stated. I am not pulling in on well with the accused, who is my husband and used to quarrel and assault me. I resided in the house of my parents on the relevant day. My husband had been to my parental house during puja and started quarreling with my parents as to why they have not sent me to my husband and abused in filthy language. Thereafter the accused tried to assault my father with a cordial, and while I intervened, tried to save my father, he assaulted on his head and belly by means of wooden sword. So what are the injuries caused to the deceased? PM doctor is?
Doctor is PW11, man.
Oh. It's on account of coma as a result of craniocerebral injuries. Open it. Hmm? Oh. So there is consistent evidence against you that, and it is supported by the medical evidence also.
Kindly have a glance to the cross-examination of the doctor, my lord.
Hmm.
I am not the treating doctor of the deceased. The weapon of offense was produced on 13/5/2020 after submission of my post-mortem report in this case. I have not mentioned the age group of the blood stain found. Weapon has not produced before him, my lord. Thereafter, after 1 month, the weapon has produced, my lord.
On my examination, I found the weapon to be long, hard, blunt type of weapon, about 2 kg, and the external injury on the skull corresponding to internal injury are sufficient to cause death in ordinary course of nature, and the head injury sustained by the deceased can be possible by striking hard with such type of weapon. କହିନି କଣ କହୁଛନ୍ତି ଆଉ କେମିତି କହିଥାନ୍ତା? The head injury detected was antemortem in nature.
My case is that due to tussle, both groups of the deceased fell down, my lord. And thereafter, brain hemorrhage, my lord.
That is your defense plea, but unless you demolish the eyewitness by way of cross-examination, merely because you say that it might have happened like that, it is not. So, have you put any question to the doctor that such injury is possible by fall?
Yes, my lord. 8, my lord. The external injury can be possible if one hard and blunt object fell down from a person from sufficient height.
कौन सी कहला यदि कौनसी जिनस ता मुंड ऊपर पड़िला तालु हेते एभली तामाने नुहे जे सी निजे पड़ी गले एमती इंजुरी ही परिबो हला कौनसी हठात किसी जिनस ऊपर बहुत ओजन रो जिनस ता हेड ऊपर पड़िला ताले देयर इज चांस ऑफ such injury being caused to the deceased. Yes, Mr. Das.
2 and 3 also supported the PW1.
PW
2 and 3.
Who is that?
Mother.
Wife. Mother-in-law.
Wife.
Mother.
Obviously, mother-in-law of the appellant.
Yes, ma'am.
All right. Heard the learning counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 2/4/2020, and as such, she has already undergone 3 years and 5 months of sentence out of 10 years imposed by the London Trial Court for his conviction under Section 304, Part 2 of the Indian Penal Code. The learned counsel for the petitioner submits that the evidence of the doctor, that is PW11, indicates that the external injuries sustained by the deceased can be possible if one hard and blunt object fall on him from a sufficient height. It is argued that there are good chances of success and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the deceased, Kantaru Maji, the father-in-law of the appellant, and on account of matrimonial dispute between the appellant and his wife, bracket PW3, she was staying in her father's place, and the petitioner assaulted the deceased on his head by means of a wooden plank, bracket लिख दूं तो cordial, CUDGEL. And the evidence of PW1, the wife of the appellant PW, to the mother-in-law of the appellant and PW3, PW3 टा की है सर?
Granddaughter of a deceased, my lord.
अच्छा, PW3, the granddaughter of the deceased, have consistently stated that it is the appellant who dealt a blow on the head of the deceased, and therefore, and the doctor's evidence, Dr. bracket लिख दें तो PW11, evidence indicates that he found number of injuries on the occipital region, and the cause of death has been opined to be coma as a result of craniocerebral injury. The Land Council further argued that the doctor examined the weapon of offense and has opined that the head injuries sustained by the deceased can be possible by striking hard with the seized weapon of offense. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced by the prosecution during trial, sentence imposed by the Learned Trial Court, period already undergone by the appellant in judicial custody, petitioner for them, absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail, stay realization of fine. order dated my lord. 17/4 ର ଗୋଟେ order pass ହେଇଥିଲା
17/4 my lord.
sir supply the deposition copy ଦେଇଦେଲେ
Yes, I have supplied.
Mr. Das
My lord.
deposition copy ପାଇଛନ୍ତି
My lord.
ଏଇ ତାପରେ ଆଉ କିଛି order ହେଇଥିଲା କି ଦେଖିଲ 21/17/4 ପରେ
Antecedent 6ଟା ଅଛି।
Short touch. I am filing the comprehension.
you are found guilty under 307 379 411 so and so 25 27 arms act
379 is not there, my lord. 307 411 page 52
379 ଲେଖା ହେଇଛି top ରେ judgment ରେ
page internal page 52 of the judgment.
acha acquitted halla oh. What is the maximum sentence imposed?
10 years, my under section 307.
But so many cases are there.
And 4 out of 6 cases.
Where is the bail order copy? Where is the bail order copies?
But in 4
Except
cases he has been acquitted. In 4 cases, item 1 to 4, I to IV, he has.
Where is the acquittal order and what is the bail order in respect of serial number 5 and 6? How can he get? He has to go from one court to another where the trial was. You have not even mentioned that in which court he faced the trial and acquitted. You have not supplied the judgment.
City case, jail case not been supplied.
The learned counsel for the petitioner appellant has filed a comprehensive affidavit wherein it is mentioned that out of 6 cases instituted against the petitioner, in 4 of them he has been acquitted and in other 2 is on bail. However, the learned counsel has not furnished the case number GR case or the city case and name of the court where the petitioner after facing trial was acquitted and date of judgment. Therefore, the land counsel for the petitioner will supply the acquittal judgment copies, so also the bail orders in the other 2 cases to the land counsel for the state. It is this matter we commencing from Good Saptah. Yes, next.
Item 83.
Take care.
Of the IPC and sentenced to arrive for 10 years and to pay fine of ₹5,000 each, your lordship.
Just deposition copy you have supplied?
Yes, lordship.
Mr. Das?
My lord.
So this is item number 88 CRLA 333/2023. So it is 304 part 2.
Yes, lordship.
10 years.
10 years.
You were on bail during trial?
No, my.
So since when you were in custody?
9/7/2020.
So you have remained in custody for 3 years?
Yes, lordship.
Okay. Who is the deceased?
This is Sureshan Naik. Sureshan Naik.
Any eyewitnesses?
Yes, lordship.
Who are they?
PW 1, 3, 5, 6 and 10.
1,
1, 3,
yes.
5, 6 and 10.
6 is not supporting. Okay, and doctor? Doctor PW 12. Let us come to the evidence of PW 1. I know this one, so I know the deceased, Suresan Naik. Occurrence took place one, so I had been to Bandha, found Suresan was sitting with so and so. After some time, they were engaged in a fight. And Sravan and Sudam dealt blow on the head of Suresan by means of Medha, Lathi. So who is the appellant here?
Here, Sravana.
Sravana. So you were sitting along with the deceased and another person was there. That is, his name is Sudam.
My lord.
And there was some kind of quarrel between you and you dealt a medha blow on the head of the deceased, as a result of which Suresan fell down and accused persons assaulted Suresan by means of a stone on his head. And then, okay, what have you elicited in the cross-examination?
Yes, Lordship. Next page, Lordship.
Yes.
I was standing at a distance of 100 meters from the spot of occurrence. None except me, the accused persons, and the deceased were present at the spot at that time. It is a fact that it was dark in the evening of the month of Shravana. I had not gone to the rescue of the deceased. I was witnessed the occurrence for 2 to 3 minutes and then out of fear fled away from the spot. I cannot say about the cause of dispute in between the accused persons and the deceased. I had not informed the police about the matter. After 2 to 3 months of the occurrence, I was examined by the police at the village. It is not a fact that Shravana and Sudam dealt blow on the head of the Suresan by means of Medha. I called Suresan as brother. It is not a fact that no such occurrence took place and that I had witnessed anything as I had stated in my examination in chief, and that I am deposing falsehood on the.
So the deceased has sustained as many as 21 injuries.
22.
21 এটি লেখা হয়েছে, and most of the injuries are on the vital part of the body.
Mitral.
That is head, ear, all these things are there. So you remained in custody for at least half of the period.
Yes, sir, Lordship.
After going through the evidence of the eyewitnesses, that is PW 1, 3, 5, 6 and 10.
We don't do all 5. Two was not examined by the IU.
That's all right. So PW 1, 2, 3, 5, 6 and 10 and the doctor bracket P who conducted post-mortem examination for the dead body of the deceased Suresan Naik and noticed as many as 21 external injuries on different parts of the body. I'm not inclined to release the petitioner on bail. However, liberty is granted to the petitioner to renew the prayer for bail if after undergoing half of the substantive sentence, the appeal is not taken off for hearing. IA disposed of, stay realization of fine. Yes.
plea.
Deposition copy
My
ଦେଇଛନ୍ତି?
lord,
Conviction କୋଉଥିରେ ହେଇଛି?
304 part 2, my lord. There are 7 appellants, including the appellant, my lord. All 6 acquitted and the appellant convicted.
ହଁ କଣ ହେଲା?
7 ଜଣ ଥିଲେ, 6 ଜଣ acquitted, this present appellant convicted, my lord.
304 part 2.
Part 2,
What is the sentence imposed?
10 years, my lord. And I was on bail during trial.
What is the name of the deceased?
Jito Rana.
Huh?
Jito Rana,
Eyewitness ଅଛନ୍ତି?
my lord.
କିଏ?
8, 9, 13.
PWs 8, 9 and 13.
PW2 also and 5. 5.
Doctor,
PW 16, my lord.
ଗୋଟେ ସାକ୍ଷୀ ଆସନ୍ତୁ eyewitness PW2 କୁ ଦେଖିବା ପ୍ରଥମ ସାକ୍ଷୀଟା.
He is the brother of the
Brother of the deceased.
my lord.
So and so deceased was killed by the accused person. So and so occurrence took place on that morning.
PW2.
Was going on. At that time, feast was prepared by so and so.
There is a group fight, my lord.
Stated about so and so.
The doctor has not found suggestion the cause of death is also homicide.
No, ये पा कहला out of them,
My lord.
Jogendra Rana
Has assaulted.
assaulted
Yes.
Jita Rana by means of
Of a
wooden
lathi.
stick.
My lord.
So ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ ଅନ୍ୟମାନଙ୍କର
ଅନ୍ୟମାନଙ୍କୁ ଏକୁଟାଲ।
omnibus nature of allegation, but ଆପଣଙ୍କ ନାଁରେ specific ରହିଲା
My lord.
ଠେଙ୍ଗାରେ ବାଡେଇଛନ୍ତି ବୋଲି, then that evidence is consistent throughout the other.
My lord.
So now let us come. Have you able to nullify this evidence in the cross examination by putting any question?
No, my lord.
No. Okay. Then come to the doctor's
My
evidence.
lord.
PW
But
16.
there is no suggestion that the cause of death is homicidal, my lord, by the doctor.
Let us see that.
My lord. PW 16.
External appearance so and so, form, internal organs. There was a bruise of size 2 cm and 3 cm over the occipital region of the head. Okay. Then
Cause of
death is due to compression of brain
stem
following intracranial hemorrhage. Okay.
There are 4 sticks has been seized in the spot, my lord.
No. Is there any evidence that apart from this appellant, anybody has assaulted?
No.
No. So you are the first.
My lord.
Yes, Mr. Das. Are the Land Counsel for the petitioner and counsel for the state. The Land Counsel for the petitioner submitted that the petitioner was on bail during trial and he has never misutilized his liberty. It is further submitted that the eyewitnesses have stated that it was a group class and the petitioner stated to have assaulted the deceased Jita Rana by means of a lathi. And the doctor has noticed one bruise of size 2 cm into 3 cm over the occipital region of the head. Though he stated that death of deceased was on account of compression of brain stem following intracranial hemorrhage. It is argued that there are good chances of success in the appeal and balance of convenience is in favor of the petitioner and therefore the bail application may be favorably considered. Land Counsel for the state, on the other hand, placed the evidence of eyewitnesses PWs 2, 5, 8, 9, and 13. And so also the doctor who conducted post-mortem examination, and that is PW 16. Considering the submission nature of evidence adduced, fact that the petitioner was on bail during trial, absence of any material that he has misutilized his liberty, absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioner on bail, stay realization of fine.
Obliged.
Next item, there are so many defects.
File in the virtual High Court.
Pardon to mention my lord, item number 7, your lordship directed to take up today, my lord. Item number 7.
ये launch ପରେ ତ ଟିକେ ଅନ୍ୟାନ୍ୟ
Fresh
ଅଛି ଆଜି
matter is there, my lord. Fresh
ये ଆସିବ ଆସନ୍ତା ସପ୍ତାହରେ।
ଯାହା ରହିଗଲା ଉପରକୁ ରହିଗଲେ